Have you ever wondered what happens when a legislator defects from his or her party in India? In the vibrant world of politics, such moves can have significant repercussions. But how exactly does the Indian Constitution handle this? Enter Schedule 10, a set of provisions specifically designed to tackle defection. These provisions were not originally part of the Constitution, but were introduced later through the 52nd Amendment Act back in 1985. They provide a clear framework to manage and penalize defections, maintaining stability in the governance and upholding the integrity of political parties. But it's not just about the penalties. These laws also help to reinforce the principles of party discipline, ensuring that legislators remain committed to their respective parties and the ideologies they represent. So what exactly constitutes a defection? Let's delve into that next. Defection, in political terms, is not as simple as changing sides. In the context of the Indian Constitution, specifically Schedule 10, defection carries a specific definition. It refers to a situation where a member of a house who belongs to a particular political party voluntarily gives up the membership of his or her party. This could also mean voting or abstaining from voting in a manner contrary to the direction of his or her party. So, if a representative decides to renounce their party affiliation or chooses to vote in a way that contrasts with their party's directive, they are considered to have defected. It's not merely about switching allegiances, it involves a voluntary and deliberate act of deviating from the party's stand, which can disrupt the party's unity and potentially destabilize the government. However, not all instances of changing party allegiance are considered defection. There are exceptions. There are certain scenarios where switching party allegiance doesn't count as defection. Now, let's delve into these exceptions as stated in Schedule 10 of the Indian Constitution. Firstly, if a member is elected as a presiding officer of a house, such as the Speaker of the Lok Sabha or the Chairman of the Rajya Sabha, and they choose to voluntarily give up the membership of their party, this is not considered defection. This exception is in place to ensure the neutrality of the presiding officer. Secondly, if a member decides to merge his party with another party, this too is not considered defection. This exception is in place to allow for the natural ebb and flow of political alliances. Understanding these exceptions can help us appreciate the nuances of political defection in India. But what happens when no exceptions apply and a member defects? That's where disqualification comes in. If a member of a house is found to have defected, they face disqualification. But what does this process of disqualification entail? Well, it's not as simple as it sounds. Here's how it works. Upon suspicion or evidence of defection, an investigation is initiated. This investigation is not done by just anyone. It's the responsibility of the presiding officer of the house. This could be the Speaker in the case of the Lok Sabha or the Chairman in the case of the Rajya Sabha. They hold the authority to make the final decision on whether a legislator has indeed defected and should be disqualified from their position. This authority granted to the presiding officer is a testament to the gravity of the situation. Defection isn't taken lightly, and neither is the decision to disqualify a member. Yet, the decision of the presiding officer isn't final. There's room for appeals. So, a member has been disqualified for defection. What's next? Well, this isn't the end of the road. The decision of the presiding officer isn't final and absolute. It can be challenged. The member in question, or any other member who disagrees with the decision, can appeal to the High Court. And if they're still not satisfied, they can take it a step further and appeal to the Supreme Court. Let's quickly recap what we've discussed. Schedule 10 of the Indian Constitution, added by the 52nd Amendment Act of 1985, sets out the provisions for disqualification of legislators on the grounds of defection. It outlines what constitutes defection, the exceptions to it, and the process of disqualification. The presiding officer of the House, be it the Speaker or the Chairman, holds the authority to make this decision. Ultimately, Schedule 10 is a crucial tool to uphold the principles of party discipline and maintain the integrity of political parties in India.